If you now look at our structure again, then we'll see what's going on here. We started, as we said, with only Denmark and Nucomed Holding AS, which was incorporated in 1999 to acquire this pharmaceutical divisions. And it also had Nucomed Denmark AS, which later would acquire Altana, right? And then we had Nucomed Holdings AS was transferred to Nuco Holdings APS in 2002, which was not the Nordic Capital Investment Funds, but the other investment fund. And then back in 2005, Nucomed AS came back as the shareholder of Nuco Holdings, and you actually have the investment by the Nordic Investment Fund again, right? And Nucomed AS initially also had this payment in kind payment obligations from 2005, which was part of the acquisition sum to buy Nuco Holdings APS. And then in 2006 they acquired Nucomed Germany Holding AG, which they incorporated, and then that set up Altana. Oh, that was set up, and it acquired Altana Pharma AG from the Altana Pharma shareholders for the 4 billion. And in connection with that, you had this huge structure set up with Nucomed Sikar at the top. Then you had two Nucomed Sweden companies. You'll see why we had two in a moment. And you had external finance, right? So you had a 500 million Euribor loan from Nucomed Sweden Holding AB to Nucomed AS, which part of which was used to pay off the 400 million payment in kind obligations, and the other 100 million, I suspect, was used to pay the interest cost for 2005, which we saw came to almost 130 million. So it's not strange that you need another 100 million in cash to pay off the interest of the previous loan, right? And then what you see is that you've got Nucomed Sikar, which then extends also a 500 million loan on the same day to Nucomed Sweden Holding AB, and Nucomed Sweden Holding AB used that 500 million to make an equity contribution to Nucomed Sweden Holding 2, which then lent the money again to Nucomed AS, meaning that there is quite a interest charge still in Denmark, right, where whatever Danish income, taxable income, is earned by Nucomed Denmark AS is wiped out completely through the Danish consolidation, through the interest cost of Nucomed AS. And spoiler alert, that interest then is not taxable in the hands of Nucomed Sikar, and that is part of the problem and why the tax authorities drove the structure so hard. So let's go and have a look at the structure, at the case itself, and see what happened. There were various investors above Nucomed Sikar through the Nordic Investment Fund, so they were sitting behind the Nordic Investment Fund, and as we talked about before, those were primarily informed investors, being pension funds, etc., etc. Now let's have a look at the case itself. Just as a follow-up on the name confusion in the case, as you can see here, in 2011, Takeda Pharmaceutical Company Limited acquired, and it's a Japanese company, as you can hear by the name, acquired the shares of Nucomed AS, which subsequently changed its name to Takeda AS. So that's why we have these two names for the same company in this case. So let us look at what the case was about. So the pleas in laws in Takeda case, okay, it says on 3rd December 2010, SCATS ruled that Nucomed AS was liable to withholding tax under Section 65D of the withholding tax, together with Section 21D of the Corporation Tax, on the interest accrued during the period 2007 to 2009 on a loan granted to the company by its parent company, Nucomed Sweden Holding 2 AB, coming to 392 million Danish kroners, which was subsequently reduced to 370 million, which comes to about euro 50 million, right? So that was what Nucomed was liable for this withholding tax. And if you look at what the legal basis is, Article 21D3 of the Corporation Tax Act states that the tax liability does not extend to interest if the taxation of the interest is to be waived or reduced pursuant to Directive 2003/49/EC, which is the parent subsidiary directive, or pursuant to a double tax convention with the Faroe Islands, Greenland, or the state of resident of the recipient company. So first of all, there is a rule that says there is a withholding tax that is due, but this on interest. This withholding tax is exempted if the creditor is in effectively a EU state or a tax treaty country, right? And it must also be entitled to the benefits of the treaty, right? And then there's also Article 65D, and that says in connection with any payment or credit or interest to a company subject to tax under Section 2(1)(d) that we've just seen, the person on whose behalf the payment or credit is made shall withhold 30% of the total interest, and that was the withholding tax on the interest. So that's how you come to this 50 million euro, and that was reduced to 25% in 2008 to be more in line with the Danish corporate income tax rates. Let's see what happens further. So before we go further, as you can see from these texts, the crucial question in this case will be whether the Swedish companies and the companies further up the structure, as you will see later, are indeed entitled to treaty protection or are indeed entitled to the Interest and Royalty Directive or the Parent Subsidiary Directive, the Interest and Royalty Directive. I said Parent Subsidiary Directive before. And whether they qualify under the treaties, either with Sweden or with Luxembourg, or the directive for protection against Danish withholding tax. Now, if we look at what the ministry said, it's submitted that Nucomed Sweden Holding 2 AB cannot claim a tax exemption under the directive because it cannot be considered the beneficial owner of the interests, and because there is an abuse of rights within the meaning of Article 5 of the directive. Now let's see what Article 5 says. Article 5 says this directive shall not preclude the application of domestic or agreement-based provisions required for the prevention of fraud or abuse. Okay, and then it goes on to say, member states may, in the case of transactions for which the principal motive or one of the principal motives is tax evasion, tax avoidance, or abuse, withdraw the benefits of this directive or refuse to apply this directive. Now there's an interesting point coming up here, but we'll discuss it in a moment. Let's just first say what the court said about beneficial owners, right? So the regional court notes that at the outset, the competence to rule on questions of interpretation of EU law lies with the Court of Justice of the EU, right? And in its judgment of 26 February 2019, the CJEU interpretation of the concept beneficial owner is that it designates an entity which in economic terms actually receives the interest paid to it and which therefore has the power to freely determine to use it. In other words, if you just have to pass it on to someone else, you're not free to use it, and in that case you're not the beneficial owner, right? The decisive factor therefore is therefore not whether the beneficiary is formally the owner of the interest, and the court also states that the concept beneficial owner in Article 11 of the OECD Model Convention, as subsequently amended, and the commentaries thereto are relevant for the interpretation of the directive. So now we know what beneficial owner is, and we see that there's a fraud and abuse article in the directive. But then there's an interesting point coming up, and it brings up a couple of sub-points that we'll look at in a moment. But the point here is that the regional court writes that it notes that the wording of Article 2(1)(d) of the Corporation Act, which merely refers to the Interest and Royalty Directive as regards exemption, is not contrary to the interpretation of the Court justice. And there were a couple of discussions here, but one of the discussions was the question, if you remember what the law said, it simply refers to Article 2.1 to the Interest and Royalty Directive, right? And in the Interest and Royalty Directive, as you can see here, member states can put in a anti-abuse clause, but they don't have to. It is one of the free choices of the members. And the question here is, if you simply refer to the directive when you implement it in the law, is that enough to say that you've also now implemented this optional anti-abuse clause? And the taxpayer argued that that's not the case. But the court says, well, it refers to the directive, and it basically seems to argue that if it refers to the directive, it refers to the whole directive, including the option of introducing a fraud or abuse, anti-fraud or abuse clause. I don't think that's a very strong argument of the court. It might still go wrong on that in appeal to the Supreme Court, but it's interesting to note that point at this stage. And then there's more coming up about this application of the court's interpretation. So when interpreting the directive, the Court of Justice also said on the abuse of rights, the CJEU states that the general principle of EU law that individuals may not rely on provisions of EU law in order to enable fraud or abuse must be interpreted as meaning that national authorities and courts must refuse to grant a taxpayer the exemption from any form of taxation of interest provided for in the Interest and Royalty Directive, even in the absence of national or treaty provisions providing such a refusal, right? So that is pretty strong language. I mean, even if you don't have a law, you still have to apply Article 5, is effectively what the CJEU said, or at least that's what is stated here. It sounds a bit like it could be pulled out of context, but it is what it is. And then if we see what Takeda said, it said that such an interpretation as established by the Court of Justice is contrary to Article 2.1d of the Corporation Act, so that a tax exemption must be granted irrespective of whether there's been an abuse of the directive. And it's all part of the discussion of, why the Danish law hasn't explicitly incorporated Article 5. But the court runs over it and it says that the wording of Article 2.1d of the Corporation Act merely refers to the directive as regards the tax exemption, and it's not contrary to the interpretation of the Court of Justice. And Takeda then tries one more time, and it says that the general principle of EU law stated by the CJEU, according to which citizens may not rely on provisions in order to enable fraud or abuse, is to be regarded as a principle at a treaty level, having direct effect for citizens, and that Denmark has not left sovereignty to the CJEU to lay down such a principle. In other words, Denmark has not has given the EU the right to say how to interpret treaties, right? Which is kind of strange because the job of the CJEU is to interpret the Treaty on the Functioning of the EU and other laws stemming from it. But fine, that is what it is. The regional court in any case notes that the principle in question must be considered to fall within the scope of an interpretation of Interest and Royalty Directive, not of the treaty, and therefore it's not contrary to Danish law or Danish legal principles. And I think the court is absolutely correct in that regard.